Recently, a same-sex couple contacted my office requesting information about a sperm donor agreement. The topic of sperm donor agreements has recently risen between same-sex couples wanting to start families in the wake of Obergefell versus Hodges, which allowed for same-sex marriages in all states, including here in Texas. Many of these same-sex couples are now wanting to start families using alternative reproductive methods, and they want to know how they can lock in their ability to parent through these agreements. Now, some questions that should come about for couples considering this are: when is a sperm donor agreement legal? Is sperm donor a parent? Can a sperm donor get rights to my child after the child's born? Should I memorialize the agreement between myself and the sperm donor? And of course, the answer to that, it's always put it in writing. But what exactly does the law say regarding sperm donors? Well, some recent changes to the Texas Family Code gives us a little bit more direction on this. And in general, a sperm donor agreement is a contract between the sperm donor and the intended parents. A sperm donor agreement is used as a productive measure and is used to clearly identify and establish the legal parentage. So for instance, although a sperm donor would technically be the biological father of a conceived child, the sperm donor agreement would establish that the donor is not the child's legal parent and that he intends to sever all rights and responsibilities of parenthood, including visitation, access, decision-making, and child support. A recent Texas case illustrates the legal ramifications of not properly securing a donor agreement between a lesbian couple and a sperm donor. In the case of In Re PS, a woman asked a friend to be a sperm donor so that she could have a child. Both the woman and the friend orally agreed that he would be the donor and not the father of the child if the child was conceived. So the friend willingly provided his sperm, and a pregnancy resulted, and a child was born in August of 2014. Now, at the hospital, both the birth mother and the biological father signed an acknowledgement of paternity form so that the biological father's name would appear on the child's birth certificate. And this is normally what happens. The birth mother attempted to rescind that agreement, that acknowledgement of paternity, rather, and because she had since the birth had married a woman and wanted that woman to be the adopted parent of the child. She claimed that the man was only a sperm donor and had no parental rights to contest the second parent adoption, and that was based on the acknowledgement of paternity agreement and the oral agreement that they had. The court, however, disagreed and found that the man was the legal father of the child and denied the right of the birth mother's spouse to adopt. The court granted the father visitation rights and set the child support obligations. And this was an unfortunate result for the same-sex couple. The court rested its decision on statutory provisions that are found in the Texas Family Code. First, the court considered section 160.702, which states that a donor is not a parent of a child conceived by means of assisted reproduction. Furthermore, the court examined the definition of what a donor is under section 160.102 subsection 6, which defines a donor as an individual who provides sperm to a licensed physician to be used for assisted reproduction. Now, in the case here, the insemination was done informally at the home of the birth mother. And because of these two factors, deciding what a donor is, the father was not considered a donor under the state law, but was in fact considered a parent. So if the parties have a artificial insemination and it's done through a physician's office, then the problems that we see in this case won't arise. The father would be a donor under the law if the reproduction had happened through a licensed physician, and he would not have been entitled to any parental rights. The lesson to learn here is that you can't handle things informally between a donor and the prospective couple. prospective parents, because the donor could later on be adjudicated to be the legal parent and not qualify as a donor under the law. The donation must happen through a licensed physician. So issues can arise to the prospective parent couple if matters aren't handled in the proper way. A donor can easily assert their parental responsibilities after the birth of the child if that role isn't clearly defined by agreement prior to the birth of the child and is affirmed by the court. So these are emerging issues, and if you have any questions about them, further questions, then please don't hesitate to give us a call here at the Palmer Law Firm. And remember, at the Palmer Law Firm, we can't protect your heart, but we can protect your rights.